Yeah, okay, I know, we're gonna go. I'm going right now. You are, sir?
Michael Pell.
All right, thank you.
Will you make sure everybody signs the sign-in sheet that's floating through?
Yeah. John? Good evening, ladies and gentlemen. My name is Michael Poshik. I'm chairman of the Hatfield Zoning Board of Appeals. We're here this evening on a appeal of a building permit that was issued by the Hatfield building inspector. And I'd like to ask Mr. Spellacy, our clerk, to read the legal notice into the public record, please.
The notice of the public hearing pursuant to the MGL Chapter 40A, Section 11, notice is hereby given that the Zoning Board of Appeals of the Town of Hatfield will hold a public hearing on the application of Michael Pill, attorney for Mary B. Dusso, and others concerning their appeal of building permit number 2012-2914, issued to Slawski Realty, Inc. and Hatfield Solar, LLC, for the installation of ground-monitored solar panels at 45 Chestnut Street, Assessor's Map number 220/lot number 118, on property owned by Slawski Realty, Inc. Applicants allege that the project is not permitted in a rural residential zone under Section 5.26 of the Hatfield zoning bylaws, and further alleges that the zoning protection for solar energy systems pursuant to MGL Chapter 40A, Section 3, is not applicable to this project and seek the revocation of the building permit. The public hearing on the above application shall be held on Wednesday, January 9th, 2013 at 6:30 p.m. in the library at Smith Academy at 34 School Street, Hatfield, Mass.
So that opens our hearing. I would like to now, as I said, I introduced myself. I'm Michael Poshik. I'm chairman of the Zoning Board of Appeals. This is Brian Nicholas. He's a member. And Fran Spellacy, also a member. At this time, I would like to also ask everyone to turn off or silence their cell phones. And I would also like to ask everyone to make sure they sign the sign-in sheet that's going around.
I want to tell people there's more chairs there, and they can use the
Yeah.
chairs that are.
Yeah, there's chairs over here if anyone wants to sit down.
They can use the computer.
Yeah. So this evening, we will be hearing from the attorneys that filed the appeal of the building permit. We will also be hearing from the attorney representing Citizens Energy, and the public will also get an opportunity to speak. Does everyone have a copy of the ground rules that was passed out? Yes, I will speak a little louder. We hope that this meeting can, that everyone at this meeting can remember that while people are for and against this project, we are all residents of the community, and we expect everyone to treat each other with respect and to please listen to each other while we have this discussion. If any of my members want to add anything? Fran?
No.
Okay. So we have a order of speakers. First, we will hear from Mr. Pill. Then we'll hear from Ms. Tolledson. Then Mr. O'Neill will speak for our building inspector, Mr. Sadowski, and then our citizens that would like to speak will have an opportunity. Our attorneys, if you could please limit your comments to 15 minutes, and we need everyone to use this microphone over here. And if you could introduce yourself when you go up to the microphone, that we would appreciate that. Citizens, we would like you to also use this microphone, introduce yourself, and we have a limit of 5 minutes for you to speak. So if everyone understands the ground rules and what we're doing here this evening, we will be able to start. The only other thing I would like to say, we are going to be hearing all the testimony, all the pros and cons this evening. And then we will not be making a decision tonight. We are going to reconvene on January 24th to deliberate and to make our decision. So I guess we are ready to start. Mr. Pill, if you could.
Okay, thank you.
My name is Michael Pill, and I guess being a real pill is good for a lawyer who often sues people for a living. Years ago, when I was called on to speak at a town meeting, the moderator who was on the other side said that, well, now we're going to hear from this lawyer. And not knowing what to do, I got up and I said, it's true I'm a lawyer, but I'm pleased to report that my children have grown up to do honest work. Hopefully none of the lawyers are insulted. I've learned over the years that if we can't laugh at ourselves in the midst of even, a fairly heated legal conflict, then a lot of other things don't matter. I have tried to put everything I have to say in writing. And David Dusso, one of my clients, has been handing copies out. If anybody didn't get one, they're in that white box over on the table. And please go over and get one, and David will give you a copy. And that's in the interest of time, because I figured there'd be a lot of people who wanted to speak tonight, and the last thing most people want to hear is lawyers citing cases into the record when you can put it all in writing, okay? What I've tried to do in the first page of this memorandum is create an outline that's the table of contents that gives an indication. And what I'll try to do here, I'm certainly not going to talk for 15 minutes, so I can sit down and be quiet, and the folks who live here and are most affected by this can talk for and against. What I try to do at the beginning is explain a little about how law is reference to authority. It's not pulled out of thin air. When lawyers start saying, for example, well, look at this argument or look at that argument, and you don't see court cases or legislation cited, that should be a red flag. Okay, because the law is in the books, and if you see a lot of legal-looking citations in here, that's what I have tried very hard to do. And the first part of it, I've tried to put some explanation that I've used in seminars over the years that helps give people an idea about how to wade through that. It's not that hard, and quite frankly, a lot of what the legal profession does is we don't want to tell you how to read court cases or read something like this for yourself, because then you got to pay me a lot of money. And that's always been kind of my pet peeve in this business. I'm an old legal aid lawyer, and I think the law ought to be open to the people. The first thing is that we have a right to an impartial zoning board of appeals panel. And I lay out in here what I think are some of the conflicts, particularly that Mr. Pashek has. And I have asked him to disqualify himself, and Darrell Williams is not on this panel, and he should be. That's nothing against either one of those gentlemen personally. It's just saying that they have conflicts of interest which prevent them from being the truly impartial decision makers to which everybody here has a constitutional right. Then I talk about pulling the thing at the application at the planning board hearing and the building inspection. The building inspector issuing a permit virtually on the same day the application came in. That's not the way this is supposed to be done. The construction cost is, I think, a real can of worms. I reproduce in here portions of the application. And one of the Citizens Energy folks in yesterday's Gazette said, we gave the town everything they asked for. Well, if you look at the portion of the application reproduced here, they're trying to tell you that the project cost for this 2.4 megawatt, that's 2,400 kilowatts, okay? 1,000 watt light bulbs require 1 kilowatt in an hour. Gives you an idea of the hundreds of houses that this is going to power. They said in the paper that a 1.7 megawatt project cost $8 million. This application says this 2.4 megawatt project will cost $3 million. Now, if they can pull that off, we are all in the wrong line of work, okay? We all need to get into the solar business because they're going to make a fortune. And not only that, the building permit fee was based on $1.7 million. The actual cost of this project, based on what the Agawam project will cost and what Department of Energy projects will cost, is somewhere between 11 and $14 million. And when the gentleman, again, the PR guy, says in the Gazette, we don't know the construction cost, I was in the renewable energy business, hydroelectric, for 7 years. If you're going to do a renewable energy project, and you're going to do what's called a pro forma cash flow, and you're going to get investors and lenders, you have to know what that project will cost. And the law requires that a building permit application state the total cost of the project. That's all in here, okay? And what that means is the town has been done out of over $40,000 in building permit fees. It was an $8,000 fee charged for $1.7 million. By that same calculation, the fee for $11 million should have been about $47,000. Now, why is that important beyond the building permit? Because the tax assessors use that total cost to assess this project for taxes, okay? Over the life of the project, if this thing is not assessed at its full value, that could cost the town, by the estimates I put in here, upwards of $3 million over 25 years. So those of you who are favoring this project for the perfectly legitimate reason that you think it's going to bring a lot of money into the town, I hope you will look very closely at what Citizens Energy has done with these numbers and ask yourself whether the town is really going to see a fair amount. And that right there is a reason to revoke this building permit and send it back for some accurate numbers. Then I talk about the legal arguments in sections 4 and 5. Conclusion is it should be revoked. In the postscript 1, I don't know if anybody's going to bring anything new that we haven't seen before today, but I ask that if somebody does have questions that can't be answered, or if we have questions they can't answer, that the public hearing be continued at least to allow for that submission. The final part, I was going to try to get this out yesterday, and I got the Citizens Energy memorandum, and I think they fell into some of the traps I've outlined. Legal arguments that are directly contradicted by Massachusetts court cases, and I put them in that postscript number 2. So if people have questions for me, particularly the members of the board, I'm happy to answer them. Beyond that, if I do have 15 minutes, if I have to answer a question later, or I would like a few minutes perhaps at the very end to try to wrap things up, I may or may not use that, but I would like that opportunity, please. And I think it's time for me to sit down and be quiet and let everybody else do some talking. Thank you very much. Would I be able to use some of that time at the end if possible?
I'll let him reserve his time.
Yes, we'll let you reserve.
Okay, thank you very much.
I'm short.
Is that what you emailed yesterday?
It is,
Thank
yeah.
you.
I'm short, so I'll try to speak up and try to speak into the microphone. Good evening, Mr. Chairman, members of the Zoning Board of Appeal, members of the public. My name is Diane Tillotson. I represent Citizens Energy and Hatfield Solar LLC, and I'm here tonight to urge the Zoning Board of Appeals to uphold the decision of the building inspector to issue the building permit to my client, Citizens Energy. Under General Laws, Chapter 40A, Section 3, and Mr. Pill has extolled you all to look at the law, look at the facts, and that's actually the decision of these members of the zoning board to do precisely that. This is a very narrow question of law, I would suggest to you, and the question is essentially what the clerk read out at the beginning of the hearing tonight, which is, does Section 5.26 of your zoning bylaw, the Town of Hatfield zoning bylaw, apply to the Citizens Energy proposed project, and is the Citizens Energy project protected by General Laws, Chapter 40A, Section 3? And I have submitted a brief memo. I submitted it through Town Council, Mr. O'Neill, yesterday, to members of the Zoning Board of Appeals electronically. It's a brief memo. It's 6 pages long, but it says everything it needs to say to respond to those two questions, which is essentially that Section 5.26 of your zoning bylaw does not apply to this project. It was adopted by the town in 2010. I attached to my memo the legislative history that supports that amendment. It's a very recent amendment, so many of you in the room probably voted on that zoning amendment at the time it came before town meeting. It was based on the town's desire to qualify as a green energy community. It was in support of solar and other alternative energies, and what it did was to provide for an area in the town that could allow for manufacturing of industrial level equipment to produce solar panels, produce them, not a solar array, and also for research and development. There's a very good guidance that was produced by the State Department of Energy that I believe was utilized by the Town Energy Committee in passing this zoning amendment, and it clearly was not intended to apply to this type of project, which is an energy generation project, not a manufacturing facility, not a research and development facility. And I know that Mr. Pill has suggested in his memo that the statute, General Laws, Chapter 48, Section 3, which protects solar energy from regulation, was not intended to apply to this size project. There's no basis for that cited in his 57 pages of legal memoranda. He doesn't suggest once a case that supports the notion that 48 Section 3 was not intended to apply to this. And quite frankly, the cases that he cites on manufacturing ignore the very recent critical legislative history that this town utilized in adopting that zoning bylaw. So I would respectfully suggest that the arguments against the building commissioner's issuance of the building permit, which was more than justified in this case, are just simply not valid arguments. I know Mr. Pill spends a great deal of time urging that the chair recuse himself. There is a very specific state statute on conflict of interest, and I would respectfully suggest, with all due regard to Mr. Pill, that the chair of your Zoning Board of Appeals does not have a conflict under that statute, 268A. I also reviewed the other arguments made by Mr. Pill. He suggests that there's something improper about the issuance of a building permit on the day it's applied for. First, I think the facts are not quite accurate there. Citizens Energy, or Hatfield Solar LLC, applied for the building permit approximately a week, to the best of our knowledge, before the permit was issued. It was reviewed, and it was reviewed carefully under Section 5.26 of the bylaw, under Section 40A, under Chapter 40A, Section 3, and the building inspector quite appropriately determined that the application for the building permit was justified and the building permit was issued. The sole responsibility of this board, this is not a discretionary permit that either Hatfield Solar or Citizens Energy is applying for here. The sole responsibility of this board is to look at the law that's been cited by me on behalf of Citizens Energy and Hatfield Solar, to look at the law as it's been cited by Mr. Pill, to consult with their town council, to listen to his view, to do the best they can, and to issue a decision that either upholds the building inspector's decision on the basis that it was valid and justified, or if the entire board agrees to overturn the building inspector's decision, they of course have that discretion as a zoning board of appeals. I'd like to also just mention one brief other facet of the law as it applies to interpreting a zoning bylaw, which is essentially what we have here. And of course, any court will give deference to a local zoning board of appeals that will interpreting its own zoning bylaw, because you're more familiar with it than I am. You're probably as familiar with it, being that it's such a recent vintage, as anybody in the room. But zoning bylaws need to be interpreted reasonably and to avoid illegal results. And I would respectfully suggest to this board that if the board adopted Mr. Pill's interpretation of the zoning bylaw, the bylaw would be in conflict with the state statute, Chapter 40A, Section 3, which clearly allows solar collection generation projects such as this. They're not restricted as to size. There's no limitation on the types of solar projects that are allowed. And I would respectfully urge that this board needs to look at the issue of whether you want to interpret your zoning bylaw in a way that it will conflict with Massachusetts law, because the courts will tell you that the bylaw, when possible, should be interpreted reasonably and consistent with the state statute, which is precisely, I would suggest, the way 5.26 was written. The authors of 5.26 were well aware of the protections of 40A Section 3 for energy and solar generation. They didn't address generation and collection, solar arrays, solar panels in the statute specifically for that reason. One final note, I'd just like to add one thing to the material that I submitted yesterday, and that relates to Mr. Pill's suggestion that the building permit fee was miscalculated. The town of Hatfield has a schedule on the building inspector's counter that anyone who wants to do any building project in the town can go in and pick up. And among the various categories of fees for building permits, there is a category for commercial solar arrays such as this one. It is specified exactly how you calculate the fee, and Citizens Energy calculated it in accordance with the town's fee schedule to the penny. There was no attempt to conceal, cheat the town, or anything to that effect. I would also respectfully suggest, Mr. Pill takes several pages of his memorandum to suggest that the state building code requires something different than what Hatfield Solar did. And I would suggest that if Mr. Pill is familiar with the state building code, he knows that appeals of building code issues go to a state board for review purposes. And that's the exclusive means for reviewing. That appeal needs to be filed in 45 days. That wasn't done here. That's 780 CMR 122, I think it's, I need my glasses, 172A or 122A. There's a Board of Appeals that would handle that issue to the extent it's a real issue. A zoning Board of Appeals is a zoning board. They have the jurisdiction to deal with zoning issues, not issues on calculating building permit fees. Again, our suggestion is we did everything right. We followed the instructions that were issued to us to the letter. We didn't underestimate anything, and that if there is a complaint about that, it needs to go to the state review board that reviews building code violations, not to the zoning board of appeals. And I have just that excerpt from the state building code on the appeals to add.
Thank you.
For all of you. And I have a copy for Mr. Clark. Thank you. And that's all I have. I'm happy to answer any questions that you might have at any time during the presentation tonight.
Would you like to reserve the rest of your time for the end?
If I have some time, certainly, and particularly if the board or anyone else has a specific question, I'm happy to address it, certainly.
All right.
Yes.
Thank you.
Thanks.
Mr. O'Neill?
My name is William O'Neill. I'm town council to Hatfield. I'm speaking tonight for Stanley Sadowski, the building inspector, who is not feeling particularly well and has asked me to speak for him. I know that this has the potential to be a long meeting, and I'll try not to add to that and just to capsulize the building inspector's position and his description of what he did. He acted on the basis that the building permit application was for a, quote, solar energy system. And he determined that such systems were not provided for anywhere in the zoning bylaws and would therefore be prohibited under bylaw section 1.4, which provides that all buildings and structures and uses of land shall be in conformance with the Hatfield bylaw. Is that better? Okay.
I understand that, but it is a microphone.
It's not amplifying.
I see. The state statute that's been referenced, Chapter 40A, Section 3, provides that no zoning bylaw shall prohibit the installation of a solar energy system or the building of structures that facilitate the collection of solar energy. And it was on that basis that the building inspector determined that the permit applied for should be and had to be granted. I also note that as part of this process, he took note of use number 526 that you've heard spoken about earlier this evening. in the table of uses in the zoning bylaws, but he determined that that applied to manufacturing of equipment, to research and development, and did not apply to systems such as the one in question, and would not serve as the basis for the permit being requested in this case. That being the situation, Mass General Laws, Chapter 48, Section 3, applies. And the issuance of the building permit was in order and indeed was required, because in this regard, I note that the original materials for Section 5.26 used to read generating facilities, so it would have applied. But that was changed by the time it got to town meeting so that it read development facilities. That's what's covered under Section 5.26. Otherwise, the application and the permit were in order, and the fees charged and paid were correct as to amount. I would also ask to reserve whatever time I haven't used.
Yes, thank you.
Okay, thank you.
All right, now we would like to hear from citizens.
Speaking for,
Yes, speaking,
in favor of the, speaking in favor of the,
Right.
the appeal.
yeah. Anyone would like to speak in favor of the appeal?
Which means to rescind the permit.
Yes.
Correct.
Can you speak up a little bit? It's really hard to hear because of this noise back here, but we couldn't hear your question.
Anyone that would like to speak in favor of the repeal? Yes, Mr. Pitchko.
Do you want us to go to the mic?
Yes, please. State your name for the record, please.
My name is Stan Pitchko, and I live on 65 Prospect Street in Hatfield. I just want to say a few comments and possibly pose questions that might provoke more thought with each of you. Ms. Tillison stood up here and eloquently put how the process had all occurred, which was pretty much synonymous to making sausage. She stated that the application was appropriately reviewed and administered, and unless she sat there and directly watched the whole process, I don't think it had. Nor did she have the right to speak on behalf of the town. Her representation is for citizens. We requested numerous times over the course of the process as to whether the permit was pulled, and we were told by Stanley that it had not been. And it wasn't until a reporter had come to the town hall and made numerous requests for that permit, which was denied, only later to find out that that permit application was sitting in a drawer and ready to be issued. So the acknowledgement of the whole permit was not appropriate. What's very interesting in the whole process was we did sit in front of numerous planning board meetings as well, and it wasn't until public pushback came that citizens mysteriously pulled their permit from the planning board, and with no explanation whatsoever. Now, there's 19 abutters that directly impact this particular property, and there's well over 50 abutters that are within 300 feet of this particular project. And we feel that we have the right to step up and ask why, in the center of the town of Hatfield, this is happening. We were told numerous times by the building inspector that this was very complicated and that it was going to take some time to put this all together, and that because of the complexity and the issues that happened throughout the entire state, that it was important to request input from colleagues and find out what was happening in other communities, as well as folks in Boston in regards to how he should move forward. And I don't believe that that had happened, and the permit was issued relatively quickly. I guess our feeling as a community, the local community surrounding the property, is that a lot of this process happened in a vacuum, and that we didn't have the appropriate time to sit back and talk to citizens and discuss what was happening, and if this was even, as a town, the appropriate location. If we start looking at our town and all the little open spaces that we have, and we start filling them up with solar or other type of industry, what are we going to be? We're looking for that time to step back and reflect, and we feel that the permit was pulled in appropriately, and we're hoping that you'll see and believe that we just want the appropriate time to make this right. Thank you.
Yes, ma'am.
Good evening. My name is
Would you
Kathleen.
put the mic down? So that-
Sure.
Thank you.
My name is Kathleen Zemer, and I live at 30 Bridge Street here in Hatfield. And I'm here this evening to speak out on behalf of the land and the rural character of our town, the wildlife that share these lands with us, and for those who love Hatfield's open space. I'm also here from my many neighbors and friends affected by the large-scale solar installation permitted for construction at 45 Chestnut Street, an area zoned rural residential. First, as a disclaimer to some individuals in this room, I feel I must correct assumptions and public statements that have been made that I and others questioning this project are anti-solar. This is far from the truth. I'm a conservationist, and I've devoted more than 30 years of my life to the U.S. Fish and Wildlife Service. During the latter years of my career, I supervised a division that oversaw the planning, development, and construction of several major visitor facilities on national wildlife refuges throughout the Northeast. These state-of-the-art facilities were built to produce solar energy, utilize geothermal heating and cooling, and incorporate recycled building materials into their construction. Their purpose was to provide a place where young and old alike could connect with the natural world, learn about our declining wildlife and natural resources, and what they as individuals could do to make a difference. Our agency received numerous national environmental awards for these LEED certified buildings, and our region became the national leader in green building technology and standardized design. After retiring from the U.S. Fish and Wildlife Service in 2008, I obtained my real estate license and earned the National Association of Realtors Green designation, meaning that I am certified and knowledgeable about issues of energy efficiency and sustainability in the various facets of real estate. Finally, when Hatfield became one of 4 communities within Massachusetts to pilot residential solar energy development, my partner and I were excited about the possibility of installing solar panels on our house. We contacted the participating solar contractor and met with their representative to discuss options for solarizing our home. However, once the design was prepared, we learned that because our house had a hip roof, we could not install the number of panels that would be necessary to adequately fulfill our electrical needs. It would also require having to remove several of our 50-year-old spruce trees that lined the western edge of our property. We just were not ready or even willing to cut down the trees. Today, solar energy is rapidly growing across our country, as it should be and needs to be. Anyone who doesn't believe we must find alternatives to fossil fuels is not living in the reality of our time. Solar energy development has taken off across Massachusetts, but unfortunately, the desire to do right, along with the economic incentives associated with solar energy development, is beginning to trump responsible planning. It seems that many projects are being pushed through without consideration for their impacts to neighborhoods or their long-term effects. Please keep in mind, I'm not referring to residential or municipal roof-mounted solar panels, but to medium and large-scale ground-mounted solar photovoltaic installations that are of industrial size. I doubt there is anyone in this room who doesn't believe solar energy development is positive. But there are those of us who also believe that the natural aesthetics of our landscape are equally important. Many of us are sustained, moved, and deepened by looking out over open space. Space dotted with fields, trees, grassland birds, and other wildlife, aging barns, and a sense of spaciousness that is only truly understood after it is gone. We read and hear often in the news about solar development on old landfills, brownfields, and in industrial areas. But more and more, we are also hearing about yet another small town facing the intrusion of a large-scale, industrial-sized solar installation. Usually, these are towns without appropriate bylaws in place to protect open space and residential neighborhoods. Citizens rise up in protest in defense of land and landscapes they have grown to love. This situation in our town is not about lack of support for solar energy development. It's about respecting one's neighbors and protecting the rural character of our town, as it is so eloquently stated in our town's master plan. It's about supporting our local farmers who, through their toil and hardship, contribute to the landscape we love. It's about working together to grow support for alternative energy resources rather than disdain. And it's about ensuring that large-scale projects of the magnitude that Citizens Energy is bringing to our community are rightly cited.
Excuse me, ma'am. I'm afraid the 5 minutes are up.
We've got 2 more paragraphs.
Go right ahead.
Okay. That they are rightly cited, not in a residential area with more than 70 homeowners who are either direct abutters or who live within 300 feet of the project. And it's also about saying no to proposals that are rooted in economic gain, both privately and corporately, at the expense of residents and the communities they are part of. And so I will end my remarks as I began. I am here on behalf of the land and the rural character of our town. I am here for the wildlife that share these lands with us and for those who love Hatfield's open space. And I am here from my many neighbors and friends affected by this industrial-sized project. It is with these interests in hand that I respectfully request you revoke this permit, that we work together to create and install responsible solar bylaws that will protect residential neighborhoods, and that we move forward together to incorporate solar energy into our community in a way that it will be embraced by all residents of our town. Is there any truer or more cooperative way for our town leadership to serve its citizens and to uphold its obligation to maintain Hatfield's unique rural character? Thank you.
Next, please. Yes?
Are you asking still about your?
Yes, come right up. You oppose the project, I assume?
Yes. Yeah. My name is Joan Cox. I live at 44 Main Street, Hatfield. Actually, I was on the fence about this project, but I have to say, having served on the Master Plan Committee and on the Open Space Committee years ago, I'm for solar energy and wind power. I'm shocked by where this is going to be sited. And when we drew up the master plan, we both wanted to preserve Hatfield's rural character. We wanted also to preserve its agricultural sector. And we developed a plan in which this would have gone into the light industrial sector of a light industrial zone in town. And I'm just completely confused about why it's instead being plunked down in a neighborhood. I also think that we have to think sort of as a society about where these solar, I don't know what you call them, solar panel fields, where they best should go. And I think it would be a disaster to see farmland across America become solar panel fields. People have come up with, I think, much better placement options for these solar panel fields. For example, as canopies over large parking lots, as rooftops over big box facilities. Even some people have talked about actually putting them down sides of roadways, especially sides of highways. So I think as a society, and certainly as a town that we love, we need to think about where this should go. And I'm with you completely. I think renewable energy is it's necessary to embrace this for the sake of the planet, but we have to be very careful about where it is put. I'm a little bit confused, and I guess I would have questions for both the lawyers about, it seems to me there's some kind of dispute about how to interpret 5.26, whether renewable or alternative energy development facilities includes these solar panel fields, or whether it doesn't. I guess there's a difference of opinion about that. I'd like to hear more about that difference on each side. And I'm also confused about the state law. Last time when this issue came up, we were told that we can't do anything about this, that according to state law, these panel fields can go anywhere, these solar panel fields, and no town has the right to restrict them to a particular zone. And now it sounds as if, in fact, the town may have the right to restrict them. Now, if the state is saying that we can't restrict them, that they could go anywhere, I think we have to fight to change state law. But I would like to hear from both lawyers about, is it that you disagree about the interpretation of 5.26? Is that one of the bones of contention here? Thank you.
Next, please. Yes, go ahead, ma'am.
Sue Mormon, 30 Bridge Street. I just wanted to say, it's also astonishing to me that a knowledgeable building inspector would grant an authority to 40A when there is a movement afoot in the legislation, or in the legislature rather, to allow towns very specifically to limit the zones in which these installations can happen. There are certainly communities whose zoning boards have decided that large-scale ground-mounted photovoltaic installations can only go into industrial and light industrial, and certainly not into residential, and that's been upheld by the Attorney General. To answer your question.
Next, please. Yes.
David Musanti, 55 Prospect Street. I've been to each public meeting on the subject that's been held so far, I believe. The couple at the Conservation Commission, a couple of Planning Board meetings, and now a meeting at the Zoning Board of Appeals. And I keep hearing the same arguments over and over again from both sides. And the thing I'm noticing about Citizens Energy and the representatives, their legal representatives, and the folks from Citizens Energy directly, is they keep saying that the committee that we're in front of does not have the jurisdiction to block the project. The conservation had nothing to do with open space. The fact that I saw a bobcat out there 2 weeks ago, the fact that I've seen an eagle back there, there's deers that cut across my property, but somehow the Conservation Commission doesn't have anything to do with open space and conservation. That is, I believe, rather narrow. That the planning board doesn't have anything to do with planning just flies in the face of common sense. And now that the building permit has been granted, that the Zoning Board of Appeals, they're asking that they have a very, very narrow interpretation of the law. And what we are asking for as citizens of this town is to have a broad discussion on how we want the character of our town to be, how we want to, why we moved here, why we bought the property where we bought it. We either are from Hatfield, like a lot of us are, or we moved here, or we worked here as teenagers, which is why I moved to Hatfield. I worked in the farm, on the Boyle farm, where the project is planned. I bought a house abutting it because I love the property, I love the open space. I was cross-country skiing back there 2 nights ago. This is, as the speaker before me eloquently stated, a great idea in a bad location. It's not what we want as a town, and I don't think we should allow ourselves to be intimidated either by folks from out of town on a very narrow interpretation of the law that they are going to make money off of, but we are going to have to sit and live with for some of us for the rest of our lives. Thank you very much.
Yes, anyone else opposed to the project would like to speak? All right. Anyone that is in favor of the project that would like to speak? Okay.
Question time.
Yep. Questions? No?
I have a
Brian?
couple of questions for the building commissioner or Attorney O'Neill who might want to answer them. First of all, the state statute, which the building commissioner relied upon to conclude that the facility could go in the rural residential district, requires that there not be a threat to public health, safety, or welfare. Could I ask what sort of criteria were used by the commissioner to make that determination, if any?
Mr. Chairman, would you like me to take the microphone?
If you
Yes,
could,
please, if you could.
William O'Neill. That language about health, safety, and welfare actually comes at the tail end of that section of 40A, Section 3, the appropriate paragraph. And what it says is that there shall be no bylaw except when necessary for reasons of health, safety, and welfare. In other words, it's to judge when there is a bylaw, whether that bylaw can stand. But there's no bylaw here.
So the building commissioner would only then rely upon the state building code in his review of the facility, along with our, since our zoning bylaw did not apply, the default was the state building code.
That's correct.
Okay. Thank you. Well, while you're there, I guess, could Ms. Cox asked for attorney's explanation, a little bit more detailed explanation in terms of why that our table of uses did not apply the section 5.26, which calls specifically the renewable energy development facilities, why that would not apply here?
Well, it does not apply because of the language. It's hard reading. But if you, to use Mr. Pill's verb, if you parse it, you find that essentially it says that in the industrial and light industrial districts, you can have solar arrays. I'm sorry, you can have manufacturing of solar equipment, you can have research and development, but it doesn't say that you can have solar arrays.
So the term development would not apply to, the commissioner concluded that that term would not apply to a solar generating facility.
Correct.
Okay, thank you.
What about the first phrase?
Ma'am?
Wait.
I couldn't, but I thought he was
He was excuse me, Ms. Cox. He's responding to a question from the Zoning Board of Appeals.
I would ask. I just couldn't hear it.
Yes.
I wasn't able to hear quite, so I just,
Excuse me, would you please come to the mic?
oh, sorry. No, it was just a matter of hearing, that I couldn't hear. Did you say, I know the phrase research and development facilities and manufacturing facilities is meant by 5.26, but the first phrase, renewable or alternative energy development facilities, that phrase, does that phrase not include facilities to generate solar energy? That's the phrase. I didn't know whether you said it, I couldn't hear.
Yes, he did say it.
So that phrase includes the solar, what do you call this, though, we're arguing
No,
about?
it doesn't include solar arrays.
It doesn't include the arrays. It's a facility, but it doesn't include the arrays. I thought that was the bone of contention. What does it mean? What does it include? Is that the bone of contention? Because I heard there's a lawyer on one side, a lawyer on the other. Seems they take different positions. So is there some, there's disagreement about that first phrase, right, about what it means. So, all right. So that's, or is it impossible to disagree about the meaning of that first phrase legally?
Well, I can't pass judgment as to whether it's impossible to disagree.
Yeah. If you could.
Remind him to address
I
the
can't
question.
pass judgment as to whether it's impossible to disagree, but as you read it as tightly as it can be read, I think that that section 5.26 essentially read all together blesses and allows allows research and development and the manufacture of equipment.
Okay. I don't have any
Hold
more
on.
questions.
You all set?
Yeah.
Mr. Pill?
Yeah, thank you.
Do you have any questions?
The answer to Ms. Cox's
I will,
question
but not yet.
is at pages 31 to 42 of this memorandum. And if you start, okay, you can't turn this thing into one big jumble. It's not.
Excuse me, would you stand closer to the mic, only so the people, when they're looking on TV, can hear you.
Okay, thank you. I appreciate that, because certainly for sound, I've never been accused of being overly quiet. I was about 4 years old when my mother said, "You ought to be a lawyer with your mouth." Okay, if you look at that section, and it was Kathy Zemer who actually identified this and focused me on it, and she's exactly correct. It says renewable or alternative energy development facilities. This is section 5.26 of your zoning bylaw, comma, okay? Any qualification that appears later about manufacture or assembly of equipment is not in that subsection within that phrase, okay? Then the next one, renewable or alternative research and development, R&D. We're not concerned with this. Now we get to the one where manufacturing is included, renewable or alternative energy manufacturing facilities, including for the manufacture and/or assembly of equipment for solar thermal. So if the limitation to manufacturing applies to any part of that bylaw, it's not the first one, renewable or alternative energy development facilities. It may be to that third one. But then, when you look at the case law I cite in here, and we've seen absolutely no rebuttal to any of that, okay? It says the word including refers to an incomplete list. And the old Latin maxim, which I can't recite, I'm from Iowa, you know, we don't deal with that. In English, it says the inclusion of some is the exclusion of others. In other words, the counter-argument, the obvious one for any lawyer, is, well, it says including manufacture or assembly. So when it says renewable or alternative energy manufacturing facilities, that must be somehow limited to only those for the manufacture or assembly of equipment. And what I'm saying is, the use of the word including under the case law that I quote in here says, that maxim does not apply here. In other words, you've got at least two phrases in section 5.26 which on their face expressly provide for this project to be allowed as a matter of right in an industrial or a light industrial zone. And that, by the way, is how we satisfy 40A3. Then we are not prohibiting this project in the town. We are allowing it as a matter of right, as 526 does, with site plan review, which is just limited review and conditioning, in industrial or light industrial zones, which is where a solar project to fuel up to 500 homes belongs. It's an industrial power plant. It belongs in an industrial zone. And that's the essence of the argument here.
I have a question.
Sure. I wish they all had votes.
So what exactly is being manufactured?
Electricity. And in pages 31 to 42, I go on and on with cases.
Could you explain to me how electricity is being manufactured?
Oh, sure. Let me cite to you the cases in here.
No, can you explain to me how the
Yes.
electricity is being manufactured?
Yes, okay.
I don't want cases cited. I would like you to explain to me how the electricity is
Okay,
manufactured.
Mr. Pashek, I will give you the plain English answer that you want. The difference is between manufacturing and processing. Let me start by processing. If I crush rocks into smaller rocks, such as gravel, I still have pieces of rock, only they're littler. That's processing. If you take something such as iron ore out of the ground and you convert it into steel, you have manufactured steel because you're changing the fundamental nature of it. When you take sunlight coming down from the sun, okay, and you convert it into electrical energy, that sunlight is not coming down as electricity. It's coming down as light and heat. And what you're doing in a solar power plant is you're taking that source of power and you are converting it into electricity. And what the law says, which is consistent with common sense, is if you're burning oil, if you're burning coal, if you're using nuclear power to run a steam turbine, if you're turning a windmill to turn the wind into electric power, or if you're taking sunlight, you are manufacturing electricity. That electricity is a manufactured product. And that's the common sense answer, which understandably is written into well over 100 years of Massachusetts case law that I cite in my memorandum. And I hope that answers your question. If not, please let me know.
What is the when in all the things that you cited, the excuse me, what are you doing?
I'm taking your photograph.
No, thank you.
I'm Mary Soares. I'm a reporter
Well, that's fine.
for WHMP Radio. Yeah.
She has a right to take photographs at a public meeting, sir.
All right.
It's on TV.
All the processes that you cited, there's a residual byproduct. There's when you make steel, you produce carbon dioxide. When you drill for oil, when you do any of those processes that you discussed, there's always some kind of residual. What residual is there in the processing of solar or
wind or hydro?
Wind or hydro? What is the residual from the sunlight being processed by the solar panel to convert it
And
into
the answer
electricity?
is there's no more in solar than there is in wind or hydro. And one of the cases I cite in there is where the court said about 80, 90 years ago that producing electricity from water is the manufacture of electricity. And the focus is not on whether there's a byproduct, but on the focus of whether the raw material is transformed into something different, namely, whatever that source of the energy is, it's not electrical energy. You can't use it to run anything. You have to transform it, and it's that transformation of the nature of what's coming through. That's what makes it manufacturing, and that's what distinguishes manufacturing from processing like crushing big rocks into little gravel.
One more question is, is a solar development taxed as a manufacturer under our from our Department of Revenue?
I believe it's taxed as real property and part of the real estate. And that's why I was so concerned about that. I think one of the ways these folks have really put one over on you is, and I note that you don't have a tax incentive financing agreement. They might get a discount, but at least you're not going to get beaten to a pulp year after year while they spend 20 or 30 grand to beat you out of 100 grand, like the Holyoke Mall used to do virtually every year. My understanding is it's taxed.
So their equipment is not taxed as a manufacturer. The manufacturer's excise tax is not applied to their equipment?
That I don't know, but
Okay.
if you, for example, if you want to give us the opportunity to submit something, I can certainly do that. You have to keep the hearing open, but believe me, I will research that question and I will get you an answer, and probably the fair way to do that would be to give the opposition, some reasonable time after my submission deadline for them to submit some rebuttal to it. Certainly, a lot of the cases I cite are electrical generating equipment, and they are tax cases. So my tentative answer, based on the research I did to prepare the memorandum that's before you, my understanding is that equipment to generate electricity is treated as manufacturing equipment, because some of the cases I cite are revenue cases.
Okay, thank you.
Okay, thank you very much.
Anything else?
I'd like to hear from citizens' attorney on the same issue, whether
Sure, just.
which category of taxation.
Yeah, very briefly, I cannot answer the tax question either. I don't know, and I'm not sure whether Mr. Houston knows off the top of his head, and I hesitate to jump into that debate. I would suggest to you that it's not relevant for the following reasons. Let me address that first, but let me first address the broader issue that I think has been raised by Ms. Cox and others. There's no way that I would suggest to you that Mr. Pill and I are going to agree on what is meant by your bylaw, section 526. And I think that lawyers, fortunately or unfortunately, maybe fortunately for us, interpret bylaws differently all the time, and that's why these cases go to court. I think in this case there are two very very good reasons that support the building inspector's issuance of the permit. First of all, you have very clear legislative history here. The bylaw in question was enacted, and I've given you a memo to that effect, in order to qualify Hatfield as a green communities, a green community under the Green Communities Act. The Department of Energy, Massachusetts Executive Office of Environmental Affairs, Department of Energy, has a very good definition of manufacturing in the context of solar energy facilities. And it defines manufacturing as those used primarily for heavy or light industry and the manufacture or assembly of a product including processing, blending, fabrication, assembly, treatment, and packaging. It does not include the collection of solar energy. Collection of solar energy is generation, and nowhere does 5.26 relate to generation. On the other hand, if you look at 40A Section 3, it talks specifically about collection of energy. And I think that's the distinction. If you adopted Mr. Pill's definition and every solar panel that was installed in Hatfield, he doesn't suggest to you, well, you know, a 0.5 megawatt facility, well, that's okay, that's not manufacturing. If his argument is correct, any solar panel installed in the town of Hatfield would be manufacturing, and it wouldn't be allowed in anything except a light industrial zone. That doesn't make any sense, and it makes your bylaw inconsistent with 40A.
That would
Section
include
3.
any panels mounted on homes.
It would include panels mounted on homes. It would include small solar arrays used to generate very small building projects. It clearly, there's no delineation, and there's clearly no suggestion in either 5.26 that that's what it was intended to apply to, and you've got a state statute that prohibits it from applying to those particular types of facilities. And I would ask that you close the public hearing tonight. I think that the board has heard a lot from Mr. Pill, has heard certainly a lot from me. We both submitted extensive memoranda to you, and obviously you need some time to take a look at it and think about it, but I don't think there's a basis for continuing the public hearing. Thank you.
Hold on, Mr. Pell. Mr. Pitchko? Also, I'd like to ask Mr. Pitchko, while you're going up, since you are an assessor, would you have any comment on the tax issue that was asked?
In regards to the tax issue, the Board of Assessors in the town of Hatfield are looking into it right now in regards to how this is going to impact the town. My understanding, and I had the opportunity to speak with the state legislator today, and they are allowing great latitude to local communities to determine how these facilities will be taxed as we move forward. And I had basically...
Well, no, just, excuse me, but the specific question about whether the solar is manufacturing, is it taxed as manufacturing? Do you have, would you be able to answer that?
The board itself has not formulated an opinion on that at
Well,
this
no,
point.
there's no law on that right now? You have to form an opinion? Wouldn't there be a law right now on manufacturing in Massachusetts?
Well, I guess if we had to err to the side of caution, we would call manufacturing what we believe converting, as Mr. Pill had said, converting one product into another product.
Okay.
So, in that regard, and I'm not speaking on behalf of the board, I'm speaking as myself, a citizen in the community. But as for the board...
well, no, I didn't ask about speaking for the board.
Right.
I just asked, as you as an assessor,
Oh, okay.
with your assessor background,
Right.
you know, could you answer that question?
Right. I would have to look at how we would convert one product to another product and then consider that manufacturing. And I wanted to take the opportunity for a second time to come up and say that this issue is obviously a very complex issue. And it's very interesting that we had to assemble here tonight on a very complex issue where one person was able to get to the place where they were able to issue a permit, where many members in the community have to rely on 3 more people to take over 2 weeks to look at everything that we've done and submitted to you in regards to whether this was done in proper form or not. I think it's very important for us to, as a community, to make sure that we're doing the right thing for ourselves. Chapter 40A was written with great latitude, and its intent was to open the door for folks to put solar panels in their front yards, in their backyards, their side yards. It was also intended for you to put it on your roof, and that isn't the bone of contention here today. We're talking about major corporations walking into a community, putting something in a place where they feel that they can. This is no longer about being green. This is no longer about being sustainable. This is all about money. And don't forget that. It's all about the bottom line and the money. We expect our leaders in our town to take a moment and reflect upon the amount of people that are in this room tonight, because it's very important as we move forward what we're doing with this town. And since we did have the wisdom to write a 5.26 many years ago, I would hope that at that time we wrote it for us as a community and not a corporation from outside. Thank you.
Oh, yes, Mr. Pill.
I found the answer to your question, I believe. It's at pages 38 to 39, and the case is Commissioner of Revenue versus Houghton Mifflin Company, 423 Mass 42, at pages 47 to 48. And I note that by 1996, the Supreme Judicial Court had considered it settled law that, quote, we have held the production of electricity to involve manufacture. They cite a 1956 case, and then the Commissioner of Revenue. And then on pages 37 to 38, I cite their complete revenue. And I believe that's the answer to your question, that the Commissioner of Revenue was upheld there, I believe, that the manufacture of electricity is manufacturing equipment for tax purposes. And that's the best I can do tonight. Now, with respect to the incorrect argument you were just presented with by opposing counsel, I cite the case law and your own zoning bylaw provisions to refute that at pages 52 to 53 and on into 54 and 55. It is completely dead wrong. It's what lawyers call a red herring, which is a distraction to say, oh my God, if you agree with Pill, you're going to prohibit every rooftop installation in town. The crucial difference, which I note in my postscript 2, this massive industrial use is the principal use of the property. Section 5.26, like your other use regulations, deals only with principal uses of property in the town of Hatfield. I note on page 53 that accessory uses, which is what rooftop installations are. If you're putting even a rooftop or a ground-mounted installation on an existing commercial or residential or industrial site, that remains the main use of the property, commercial, residential, industrial, or whatever. The solar is an accessory use, and it's pretty well established by this time. Section 6.12 of your bylaw says, and I quote, accessory use customarily incidental to any permitted use, close quote, and there's little yeses all the way across. They are allowed as a matter of right in every zoning district. What you decide here has nothing to do with that red herring that's been dragged across our path by opposing counsel. And I note, just to elaborate, I cite the criteria for accessory use, and the case is Town of Harvard versus Maxam. Now, with respect to the documents that are being thrown at you, and I note, interestingly enough, that 2 documents were thrown at you, and it appears one of them may have been dropped, because it's the man, sadly, who now owns your house, Mr. Pashek, and that's Christopher Smith, who I believe has testified before the planning board in favor of this project. He is a staunch advocate of this project, which of course he has a right to do.
Make your point, please, Mr. Pill, and we're going to wrap this up.
And I noted, sir, I'm sorry to raise
I noted
this.
it too, sir. Make your point, and you will be able to sit down.
Sir, you've put this personal financial issue at issue by sitting here as a
No,
public
sir,
official.
I have not put it.
Excuse me.
I have
Enough,
not put it.
enough.
You have put
This
it.
is getting very personal. State your case and your stay, and then.
You can sit down.
Not
You
in-
Very
have,
well, sir.
you have made it personal. You have made it personal. You can finish up, and you may sit down.
Very well, sir.
Your time is done for this evening.
May I finish the statement?
Yes,
with
finish your
respect to
statement.
legislative history?
Yes.
Thank you for allowing me to continue to speak, at least to that issue. I cite at pages 55 to 56 that the limitation on legislative history is official legislative records. There is no indication that this state document, whose author we don't know, was in any way part of an official legislative history for the town of Hatfield's zoning bylaw adoption of Section 5.26. And the court notes that we focus on the wording of the legislation, which is what we've been focusing on here today, and official records. And what I respectfully submit, sir, is that neither that letter from Mr. Smith, because the case law specifically says after-the-fact statements by legislators, which in this case includes Town of Hatfield voters, are completely irrelevant. There's a line of cases that say those count for absolutely nothing, and there's absolutely nothing to suggest that the extraneous document that's being brought in by an unknown author affects the legal meaning of the words used in your zoning bylaw. Thank you very much.
Thank you. We will take it under consideration. Do we have any other questions?
No, I have
Got one back there.
Yes, sir.
I don't have a question, but I do have a statement.
For or against?
Are you for
My
the...
name's John Zakowski. I reside at 49 Gore Avenue.
Yes, sir. For the project, against the project?
I'm not for it.
Okay,
I can't support it.
okay.
But what I have to say is very, very brief.
Excuse me, would you give your name again?
My name is John
No, into the
Zakowski.
mic so they can...
If you can't hear that. Zakowski, 49 Gore Avenue in Hatfield. And what I have to say is very, very, very brief. If we are to continue calling ourselves a community, then whether we are financially powerful or weak or influential or not influential, we shouldn't undertake projects that will negatively devalue the property, the homes of others. I consider everybody in Hatfield my neighbor, whether you live next to me or up on a mountain or wherever. You are my neighbor. You're part of the community. I consider myself part of the community. I'm here. I've been here over 40 years. The state says in their guidelines for the development of these industrial-sized arrays, if you want to call them, or call them farms or peanut plantations, that they suggest very strongly that we not develop these in an area where they will devalue someone's property. And if we're going to continue to call ourselves a community, we shouldn't be crapping on our neighbors and devaluing their property. We can live without it. We don't need it there. And we already state, put it in light industrial, put it in commercial. Thank you.
Thank you. We're going to close, we're going to stay open for,
Let's talk about it.
huh?
Let's discuss it.
We have a lot of materials to read over,
Yeah.
so,
I have no questions. You have any questions?
Yeah, I don't need any,
I don't need more.
I really don't think I need any additional
I don't.
information.
No.
I've got
We
everything.
could allow anyone to respond in writing
Yeah.
to us, even if we did close the...
7 days.
We said it, 20, we
yeah,
say the 21st?
By noon on the 24th.
Yeah.
Or before that, we need time to read it.
Yeah, 3 days before.
Yeah.
We said the 21st, right? Did you get that? You had that one in our meeting. You didn't.
21st is Martin Luther, so by the 22nd.
Okay.
Yeah.
All right, and we're going to close now.
Well, I'll make a motion. I'm going to make a motion that we close the public hearing portion of the appeal.
We're going to
but-
wait until we heard from the legal arguments.
Sir, I'm
Just hold
I'm
on.
making a motion here.
Yeah, he's making a motion.
So I'm making a motion that we close the public hearing, but that we do allow written statements from any party to the board due on or before January 22nd
At noon.
at noon time. All right. That's my motion.
I second it.
Any discussion? All in favor?
Aye.
Aye.
And those submittals will go to the town hall, to Miss Davis's office, in care of us.
And we're going to meet on the
24th.
24th at what time?
I don't know if that's been determined yet.
Time wasn't determined.
6:30?
6:30
Okay.
here,
Uh,
or town
Yeah,
hall.
I don't know if, I think we'll probably have a few people, so we should make sure we get the facility.
Here,
Yeah.
yeah, all right.
What time, what date do we?
So we're going to meet, our next meeting will be on Thursday, January 24th, 6:30, here in this room. Okay? Thank you, everyone, for coming, and motion to adjourn?
Motion to adjourn.
Mr. Chairman,
Yes,
can there just be clarity? Is the public hearing closed
Pub-
except for the written submission?
yes.
Thank you.